Good afternoon. This is Delvin again. Santano, I think you can proceed and start the meeting if all the team members have joined. We are trying to get with the other judge. So in the meantime, please proceed and start the session.
Okay.
Thank you.
Thank you. Good afternoon, everyone. So kindly introduce yourself.
Hello, I'm Fatima Namazi, and I am the Senior Counsel for the Appellant, and I'm with my colleague, Mr. Simon Osai, and he is the Junior Counsel for the Appellant.
Okay, great. Welcome, Fatima. Welcome. And the respondents?
Good afternoon. My name is Ikra Islam, and I will be representing Senior Respondent, and my co-counsel Fazlullah Muhammad will be representing Junior Respondent.
Yeah, right. Again, nice meeting you again. I think we were in the first session together, right?
Yes, yeah.
Yes, nice meeting you.
Yeah. Okay. 1 second. Okay, so I'll request the appellant to start.
Hello, I'm Fatima Namazi, and I'm the Senior Counsel for the Appellant. If it's all right with your honor, I will give a little context and background, and we'll provide one submission. Our client, Mr. Payne, has met Ms. Rani on this platform, Clavity, and they both came together because they wanted to use their own platforms to help each other and to grow from there. Unfortunately, overnight, Clavity did a routine upgrade, as stated in the scenario, which ultimately caused a glitch. Which caused Ms. Razi to owe about $250,000 and therefore brought a claim to the courts. With my client, Mr. Payne, he only had subsequent knowledge about his own programmer, and when he programmed Mr. Razi's as well, he did not know that the glitch or Ms. Razi to owe $250,000. He did not know that. He did not know that that was going to happen. Clavity was also involved with the disputed trade, which, like I said, my client did not know anything about it. My client used Article 37 of the DIFC contract law, which he used that to defend himself, that he only knew about the knowledge about his programmer and the, I suppose, contract that he made with.
I'll just pause here a bit, if you don't mind. So, what are the two main issues against which you are appealing? Let's come to that.
The main appealing is that Mr. Payne did not know that anything. Well, he didn't know that Ms. Razi was going to have to pay.
I'm asking the two issues which have been decided by the first instance court. So what are the two issues which are now before the appeal court? you have your pleadings, you have placed your submission. So have a look at it and see.
My lord,
Yes. We can't hear you. We can't hear you, Mr. Counsel. We can't hear you. Ms. Fatima, should we continue?
Unfortunately, I cannot answer your question. But
can you hear me now?
Yeah, kindly introduce yourself. Yeah, Mrs. Simon.
Thank you, my lord, and my apologies for the technical glitch. My lord, I'd like to address the question you put forward to my senior counsel, Ms. Fatima Nazuri. The two issues which the appellant, Mr. Lepe, whom we represent today, bring forward to this court is first, jurisdictional challenge for the court to determine if the DIFC has jurisdiction on this matter. The second issue, if the DIFC do have jurisdiction on this matter, the next ground is for the Court of Appeal to determine if the DEC correctly came to its decision. Simply put,
That's
was
fine.
the DEC required to...
Understood those 2 points. If we have gone through the process of this moot court competition, the DIFC moot court competition rules and everything, the points are allocated on the basis of senior counsel and junior counsel. So should I take it that you will be addressing both the points?
Yes, my lord.
Okay. But we'll have to see whether you will be entitled to get the points as per the DIFC moot court rules for both the issues which you are arguing. Because Ms. Fatima, I mean, is she okay? I mean, is she opting out or?
I'm okay with Mr. Simon Osai to carry on with his argument.
Okay. Okay. Let's continue.
Should I progress?
Yes, please.
Yeah. My lord, my colleague, senior counsel Fatima Nazri has briefed you with the essential backgrounds to this matter. I'd like to take our grounds of appeal one at a time. Our first ground of appeal is the issue of jurisdiction. It is the case of the appellant that the DEC courts, and by extension the DIFC courts, do not have jurisdiction to determine this case. Although the DEC courts determine that he has jurisdiction under Article 5A1B of the Judicial Authority Law, Dubai Law number 12, 2004, it is the case of the appellant that indeed that article is not applicable to this case. And the reason is, under Article 5, A1B of Judicial Authority Law, Dubai Law number 12, 2004, a civil or commercial dispute will be determined or considered to be within the jurisdiction of the DIFC if the contract was concluded or entered into within the jurisdiction of the DIFC, or if the contract was operated or performed within the jurisdiction of the DIFC in whole or in part. In the present matter at hand, these criteria were not met. It is common ground that both parties, neither of whom lives within the jurisdiction of the DIFC. It's also common ground that their individual programs which they created for trading is not based within the jurisdiction of the DIFC. What is common ground is that Clevity, which is a platform they use, is an electronic platform and has several nodes in different jurisdictions, the DIFC being one of those jurisdictions. My lord, the case of the appellant is that the parties would not reasonably have entered into an agreement that lends itself to such a wide range of jurisdictional choices. Because if we go with the respondent's case, that because of the simple fact that a single node operates within the DIFC, that will then amount to the DIFC having jurisdiction. What that means is that all the other jurisdictions can also lay claim to having jurisdiction to determine this case. And obviously, this will make a mess of the principle of choice of law and choice of jurisdiction. My lord, there is nowhere in the contract that states expressly the jurisdiction for this agreement. In that case, only two options would apply. The first will be for the case to be determined by the jurisdiction where either of the parties live. So if we apply the case of Enka and Chops, which is the UK Supreme Court, I make the point to remind the court that the DIFC courts find persuasive decisions of higher courts of other common law jurisdictions, which UK is a common law jurisdiction. So if we apply the principle from Enka and Chop, the principle of the closest operative jurisdiction to either of the parties, then we would see that the DIFC does not have jurisdiction because neither of the parties resides in the DIFC. If that option is not favored by the court, the second option would be for the parties to agree and nominate which jurisdiction they would like the case to be determined by. I make the point that there is no such agreement so far, because if you go back to the backgrounds from the court of first instance, it was mentioned that my client, which is the appellant, did raise jurisdictional point of challenge. My lord, having dealt with ground one of our appeal, I would like to move to ground two. The ground two of our appeal is that in the event that this court does find adversely against my client that it has jurisdiction to determine this case, the second ground of appeal would then be to assess if the DEC court correctly applied the DIFC contract law to this matter. My lord, Article 37(1)(a) of the DIFC contract law requires that in determining an agreement, determining whether a contract is void or voidable, the court would have to examine the state of mind of the parties. What the DEC has done in his determination was to exclude entirely that part of the law. And so they made a decision in favor of the respondent based on the fact that it was reasonable, based on the objective approach, that if a reasonable trader having knowledge of the background of this trade would conclude that it was conducted in error and so should be voided. My Lord, I make the case on behalf of my appellants that these are commercially astute traders. Both of them created separate programs for trading. Both of them had the foreseeable risk. It was reasonably foreseeable that they knew that a trade which is automated in this manner would not be a stranger to any technical glitch. It's common ground that Clevity, which is the platform they use for their trading, usually suffers technical error. And both parties were aware at the time of agreeing the contract. It's also common ground that both parties didn't intend to have human input in the agreement. And this is why they automated the trade. It's common ground that neither my client did not do anything to change the course of action with regards to how the trading platforms operate. And so, once both parties were reasonably aware of the risk, what this court will then have to consider is Article 37.2 of the DFC contract law, which says that where a party enters into a contract, being fully aware of the risk will rest there. And so it is the simple case of the appellant that the respondent entered into this contract, being fully aware of the foreseeable risk, and so cannot now go back on his promise to, permit me to use that word, dock his or her responsibility from allowing this contract to be concluded. My Lord, the background facts to this case informs us that these programs are deterministic in the sense that once they've been programmed, they will never change the course of action. And so there is no evidence that was adduced by the respondent to suggest that just because Clevity platform suffered an error, that automatically meant
We can't hear you.
Are you with me, my Lord?
Yeah, now, yeah, we can hear you now. Yeah.
Thank you. There's no evidence that was adduced by the respondent that because Clevity platform malfunctioned, that in itself does not mean that the program by Ms. Rani malfunctioned and the program by my client, Mr. Litton, malfunctioned. Those are deterministic. They would operate irrespective of any external factors around them. And so no evidence have even been adduced to say that the node which the respondent lays claims to for issues of jurisdictional purposes, that node actively operated during this particular transaction. In the light of the above, my Lord, I invite the court to grant both grounds of appeal. First, to determine that it has no jurisdiction, and if it does that, then the second grounds of appeal will automatically fall through, because there will be no grounds upon which the court will then consider whether it can apply the law of the DFC or not. But in the event that the court finds adversely against the first ground, the alternative submission of my client is that the DEC court erred when it did not examine the state of mind of the programmers, because what the DEC has done at that point was to take away the voluntary nature of contracting. So it's taking away the powers out of these two people who voluntarily decided to make a contract. And that in itself is repugnant to natural law. But also, these two people are fully aware of the risk. And that risk has not, that they're fully aware of, the respondent has not done, showed anything at all to say contrary to that risk, that risk should be limited. The risk was not defined, it was left open-ended. And so we cannot now say that because he sold at 250 times above the market rate, that he's lost his commercial papers. Because if the parties wanted to limit the risk, they could have done that at the point of contracting, but they willingly chose not to do so. Thank you, my lord.
So basically what I understand, that as far as jurisdiction is concerned, if I ask you a question, which is the court which should have jurisdiction?
My lord, I think that can be dealt on two fronts. One of the parties reside in Oman and the other one reside in Dubai, but outside the DIFC. If it's agreed between the parties, either of those jurisdictions could have jurisdiction, because obviously whilst they were entering into the contract, they were based in this jurisdiction.
And what about the cause of action?
Can you rephrase your question, my lord?
The cause of action, how do you see the cause of action as far as jurisdiction is concerned?
In what sense, my lord?
Like normally we have three issues in a jurisdictional matter. One is where the opposite party resides, where the opposite party carries on business, and where the event happens, that cause of action happens, the issue from which the dispute arose.
Yes, my lord. Yeah, as I mentioned earlier, determining jurisdiction will be on two fronts. So if they agree to use either of the place where they reside, that will be fine. If they don't agree, they can nominate a third party place where they
Suppose they don't do that. I mean, normally what happens when one party is aggrieved, he or she just goes ahead and files a case as advised by their lawyers or whatever they think fit. So in the absence of any written agreement regarding the place or location where a case has to be filed, there are three important issues. One is a place of residence of the defendant. Number two is the place of business of the defendant. And the last point is, if the first two are not satisfied, or even if they are satisfied, number three can be the place from where the dispute arose, the dispute started. So in this case, particularly, what do you think? What is your point of view, where the dispute started? Let us assume that both the parties are in the same location.
Yes.
Okay, let us assume that. Then if you consider the last issue, right, that where the dispute arose, how do you define that? Whether the dispute arose in Dubai, outside DIFC, or in DIFC, or in Oman, or any other place?
My lord, I'll take the position that the dispute arose outside of the DIFC. And since it arose outside of the DIFC, it is not the place of the DIFC courts to claim jurisdiction, because if we are pegging our point, if the respondent is pegging his point on the fact that there was a node, this node is operated in several jurisdictions, we couldn't reasonably argue that that then gives right. It was a passive node. And so the jurisdiction is outside of the DIFC.
Okay, so I take it from you that because there are many nodes across the continent, in that case, if you choose a particular jurisdiction like DIFC where one of the nodes is there, then people are free to choose any jurisdiction. That is what is your point, right? Because the nodes are across various places. It's not only in DIFC, it's in various countries. In that case, if we accept DIFC as the jurisdiction, then we can also accept any other country as a jurisdiction because nodes are also there. Because Clevity has nodes across. If it is what is you are saying, if my understanding is correct.
Yeah, my lord, yes. If we're to go with the respondent case, that's what it would mean. But what the appellant is saying is that we couldn't go that way because it's a rabbit code. We couldn't have several jurisdictions claiming to have jurisdictions on this matter. What we could do are two things. The parties entered into disagreement from living in separate jurisdiction. We can go to either of those jurisdictions, or the party can agree to nominate a more neutral jurisdiction. And if they do that, perhaps they can nominate the DFC, or they can agree to nominate any other jurisdiction.
Okay. Okay, thank you. Thank you. So it's time for the respondent.
Thank you, ma'am.
Good afternoon.
Good afternoon.
Should I begin?
Yeah. Sure.
Good afternoon. Okay, good afternoon. May it please the court, counsel. My name is Ikra Islam, and I, with my learned junior, Fazlullah Muhammad, will be representing respondent, Ms. Raz Rani. With the permission of the court, the respondent is responding to the appeal of the Digital Economy Court by the appellant to disprove the appellant's claims and to prove that the court dismissed the claims on challenging the court's jurisdiction and presented a judgment on the right points of law. The respondent will respond to two claims in the order of the appellant itself. First, the Digital Economy Court of the DIFC has jurisdiction over the claim of respondent under Article 5A, 1, subsection B and D of the Judicial Authority Law, Dubai Law number 12 of 2004. And the second ground, which will be addressed by my junior Fazlullah Muhammad, which states that the court correctly concluded that the appellant, a reasonable trader with knowledge of the circumstances surrounding the transaction, would have concluded the disputed trade was the result of an error sufficient to satisfy Article 37(1)(a) of the DIFC contract law. Presenting the first ground of appeal, in first instance court did not err in concluding that Clevity operated a distributed ledger with a node in the DIFC, which gives the DIFC court jurisdiction over the claim of Ms. Razi against Mr. Payne under Article 5A, 1B of the Judicial Authority Law. Your Honors, would you like the respondent to present the facts of the case according to their interpretation of the events?
Yeah, sure. Yeah,
Sure.
go ahead.
Okay. Both parties trade on an online trading platform called Clevity in cryptocurrency YAPO. This online trading platform uses a distributed ledger, which is hosted across hundreds of digital nodes in different countries, as mentioned by Your Honor previously. One of the nodes is on the server in the DIFC. The users on the Clevity platform must maintain a cash of US $50,000 in their accounts. The platform Clevity allows users to undertake a logarithm trading trades can be concluded without any human involvement. The Appellant's program called Beta is created to offer to sell Yapple at the average price of all sellers, and in absence of other sellers at an inflated price. The respondent's program Alpha buys Yapple at an inflated price. There was an error on the Cleverty platform during regular maintenance on 10th June 2022, which caused the respondent to buy at a price 250 times greater than the market price. Cleverty automatically settled the disputed trade and made the relevant transfers of funds, while the parties were asleep and unaware of the events on the platform. It is to be noted that the parties did operate from different locations as the Sultanate of Oman and Dubai. The transactions on the databases still occurred, and as nodes processed and witnessed every transaction, the node in the DIFC did the same. Moving to submissions, the first instance, the court did not err in determining the DIFC has jurisdiction over the respondent's claim, as the contract was concluded in the DIFC as concluded on the Cleverty's distributed ledger system. The node in the DIFC gives jurisdiction as a distributed ledger is defined as an asset database that can be shared across a network of multiple sites, geographies, or institutes and nodes, as shown under the report by Government Office for Science called Distributed Ledger Technology Beyond Blockchain, year 2016 on page number 5, also mentioned on the respondent bundle. I've also referenced another source under the DIFC itself, Dubai Financial Services Authority, which defines the same definition. Moving on, node on the network is meant as a processor of information for the network of nodes. Transactions are added to the database in blocks and is reviewed by nodes, as shown in the UK jurisdiction under the UK jurisdiction Task Force Legal Statement on Crypto Assets and Smart Contracts. Moving to the case of Zippo Manufacturer Co. against Zippo.com, where the court stated that it has personal jurisdiction over a website originating in a different territory if the website is accessible to internet users in the court's territory. Hence, Cleverty's node in the DIFC is sufficient evidence for the Digital Economy Code to conclude that the disputed trade contract was concluded in the DIFC because the node serves not just as a medium of information exchange, but also the location of the DIFC for finalization of the contracts. Moving on to proving this further with the second point, which is in regards to the interpretation of Article 5A2 of the Judicial Authority Law, the court has determined the meaning and scope of Article 5A of the law and Article 20 of the DIFC Law number 12, 2004. The law states that DIFC Court of First Instance has original jurisdiction of Judicial Authority Law to hear the following civil or commercial claims and dispute arising out of or relating to a contract or promise contract, whether partly or wholly concluded, finalized or performed within DIFC, or will be performed or is supposed to be performed within DIFC pursuant to express or implied terms stipulated in the contract. To know specifically Part 2 of the Article 5, it states that DIFC has jurisdiction over contract between claimant and respondent, as a node in the DIFC does substantiate the contract being concluded. Also to mention here is that if presence of a node does not give jurisdiction, nodes being worldwide would result in no jurisdiction for the disputes at all. There wouldn't be any kind of jurisdiction. Now moving to the case.
I have a question here. Just a question. You just said if DIFC, if a node, presence of a node doesn't have jurisdiction, then the presence of the nodes in various countries will not at all have jurisdiction. So what about so what about the issue whether defendant stays or defendant carries on business? Doesn't that confer jurisdiction as well?
Can you just repeat that? I'm sorry, I didn't get the last part.
Yeah. So what about the location where the defendant stays or the defendant is carrying on business? Doesn't that confer jurisdiction for filing a case?
It depends. Again, this is an online platform. So and the transactions are held online. So either the parties decide beforehand they are going to be on a specific, they're going to decide on a specific jurisdiction, or they can or it can be done through a main office as well if there's a main office displayed on the contract. It's all on the contractual terms by the
So
commercial parties.
you're saying in the absence of some specific clause to that effect, then it is enough to have jurisdiction when one of the nodes is in a particular jurisdiction, right?
Yes, I agree with that. And also under the DIFC law, it is stated that when both parties don't decide on a jurisdiction, DIFC laws apply.
No, law is something different. Law and
Yeah, but
law and the law is something different, and place is something different. Location is different.
yes, yes. So, but according to the DIFC law itself, that's what I was. I'm sorry if I was misinterpreted in that regard. According to the DIFC law, if both parties don't have a specific jurisdiction, one of the party, the DIFC jurisdiction will apply. So DIFC will have jurisdiction if they don't decide on one.
Can you read out that part?
Yes. So I'll just go on when I explain the case itself. So in the case of Leadham against Oxford Investment, where the reasoning of column judge was applied from the case of Khalil against Shua Capital, again a DIFC case, it stated that jurisdiction of the DIFC code at first instance has original jurisdiction in line with Article 5A2 over commercial cases and disputes. The article gives a requirement that the transaction shall be related to DIFC activities. And in this case, these are DIFC activities because the node is present in the DIFC, which simply means that such transaction should have been as a result of a particular commercial activity carried on in the DIFC, which is exactly the case at the matter at hand. This was also established in the case of Al-Khurafi against Bank Sarsin, 2011. In regards to Part 5 of the DIFC Law number 10, 2005, which is applicable for the interpretation of Article 5A, 1B, the test prescribed under Article 16.5 of the DIFC Law regarding the establishment of jurisdiction in commercial contracts must be applied, which states that if the parties do not specify the governing law of contract, the contract shall be governed by the law of the DIFC.
Okay.
I hope that answers your question, Your Honor. In conclusion, the presence of clarity's node in the DIFC thus substantiate the first instance court argument of the contract of the disputed trade being concluded in the DIFC. The respondent requests the court to dismiss appellant's appeals on the reasoning presented by the respondent. Thank you.
Thank you. Anyone from the appellant who wants a rebuttal here, who wants to put up a rebuttal? Mr. Simon?
Yeah, my lord, thank you. Yes. My lord, the counsel for respondent made the claim that the node which belongs to Clarity being one of the nodes being within the DIFC amounted to it giving jurisdiction to the DIFC courts. My lord, no evidence whatsoever was adduced by the respondent that the node played an active role during the conclusion of the disputed trade. And as we mentioned earlier, the programs that conducted the trade itself were deterministic, in the sense that once they've been programmed, they will not change their course of direction due to any external factors. Also, the respondents in their submission, do you accept that there was some level of risk? But their argument is that exchanging cryptocurrency at a market rate 250 times higher will not be one of those risks. What we say to that is that...
No, Mr. Simon, we are only on the jurisdiction issue now.
Okay.
So the main issue is what the respondent has just said, that the presence of a node in DIFC is enough to confer jurisdiction on DIFC. So I will request you to keep your submissions to that, up to that only, that why the presence of a node in DIFC do not confer jurisdiction. That is the question.
Thank you.
We'll get into the second issue later on once the respondent comes up with the other counsel of the respondent comes up with that.
Thank you, my lord. The node will not amount to the DIFC having jurisdiction because there are several nodes across all the jurisdiction, and it's not reasonable that all these other jurisdiction will have jurisdictional powers over this case, because then where would one try the case? Where would one conduct the case? Also, there is no evidence that the node played an active role. After all, it's agreed that.
So what is the role of a node? I mean, you just said the node did not play an active role. There was no evidence to that effect. So what is the role of the node in this particular transaction?
Well, a node is like a pathway or an intersection used in blockchain. But as already noted in the facts, the Clevity platform malfunctioned. That suggests that the node malfunctioned. The role had no role to play. The trade was conducted based on these or that two deterministic components or programs, which would normally conclude a trade irrespective of any external influence, because it went on to conclude the trade even though the platform which belongs to Clevity malfunctioned, and is agreed that Clevity does not have any liability, which means that the role of Clevity and its node is very limited to the real issue. The real issue is where were the parties based? That should be the jurisdiction for this case, or where would the parties agree to nominate to be the jurisdiction for the case? Thank you, my lord.
Thank you. Okay, so I'll request the respondent to come up with the second issue.
May it please the court, as introduced by my learned senior, I am Fazlullah Muhammad, appearing as junior counsel for the respondent in this appeal, Ms. Razrani. Your Honor, I will address the second ground of appeal and attempt to convince this court to uphold the decision of the learned judge in the court of first instance, which was indeed based on sound legal reasoning, and conclude that the disputed trade can be voided for unilateral mistake by showing that the appellant had constructive knowledge of the respondent's mistake. In this regard, I'll be making 2 points based on statute and case law, establishing that first, constructive knowledge is sufficient to establish the doctrine of unilateral mistake, and second, how constructive knowledge can be inferred on part of the appellant. I would like to note to this honorable court that I'll be relying upon case law from other common law jurisdictions due to the scarcity of case law in the DIFC jurisdiction itself on this matter. With the court's permission, I shall now begin my submission.
Yes, please.
Your Honor, the court of first instance did not err in concluding that for the purpose of a claim to avoid the disputed trade for unilateral mistake under Article 37(1)(a) of the DIFC contract law, it was sufficient for the respondent, that is, the mistaken party, to show that the appellant, that is, the non-mistaken party, as a reasonable trader with knowledge of the circumstances surrounding the disputed trade, would have concluded that it was a result of a mistake. In other words, it would be sufficient to show that the appellant, as a reasonable trader, had constructive knowledge of the mistake as opposed to actual knowledge. This is contrary to the contention of my learned opposing counsel, who says that there was no exploration of the state of mind at all. While in fact there was an exploration of the state of mind, but it was an exploration of the state of mind of the traders who would or would not have concluded a reasonable trade given the circumstances, rather than the state of mind of the programmer due to the deterministic nature of the algorithms. Your Honor, Article 37(1)(a) of the DIFC contract law provides that, and I quote in verbatim, a party may only avoid a contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known. And A, the other party made the same mistake, or was also mistaken, or caused the mistake, or most importantly, or knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. This means that the disputed trade can be avoided if the appellant ought to have known of the significant unilateral mistake on the respondent's part. In other words, the disputed trade can be avoided if the appellant had constructive knowledge of the mistake. While my learned opposing counsel may dispute this based on the fact that the parties entered into the contract knowing the risks, I would like to respond to this by stating that the established background facts state that the parties entered into the contract on the Clevity platform based on standard terms and conditions, and there has been no mention made of the limitation of any possible limitation of risk, and that the parties, when adhering to the standard terms and conditions, did not have in mind that such an unforeseen event would take place, causing the said transaction. That is, in other words, as reasonable traders who undertook trades on the Clevity platform, any reasonable trader, just like the parties, would have concluded that given the circumstances of the transaction, a valid transaction would not stand. If Your Honor would kindly turn over to the highlighted portion on page 22 of the respondent's bundle, it can be seen that this provision of the DIFC contract law is based upon Article 3.5(1)(a) of the UNIDROIT Principles of International Commercial Contracts 2004, which consists of the same language as the DIFC contract law. The relevant elaborative commentary, which is the first highlighted portion on page 24 of the respondent's bundle, clarifies that for a contract to be voidable due to unilateral mistake, the non-mistaken party must satisfy any of the four conditions found in Article 3.5(1)(a), and for the purpose of this appeal, the relevant condition is the third. That is, the non-mistaken party ought to have had constructive knowledge of the mistake, following which it would be unreasonable and unfair to leave the mistaken party in an erroneous state. If Your Honor would kindly look at the second highlighted portion on page 24 of the respondent's bundle, it can be seen that the commentary further provides that the test for constructive knowledge is that the appellant's constructive knowledge should be the same as what a reasonable person should have known if they were in the same position as the appellant. This shows that the DIFC law and UNIDROIT law accommodates the fact that it is not important that the programmer's state of mind should be taken into account when determining upon such an issue, but the fact DIFC law is concrete in the fact that a possible test for determining this issue is that one of a reasonable person test, that a reasonable trader in the same position with knowledge of the circumstances would not have concluded the reasonable trade. Your Honor, adding to this point, any reasonable trader who regularly undertook algorithmic trades on the Clevity platform, like the appellant, should have known and would have developed the awareness that the sale of YAPL at 250 times higher than the market price was an abnormal situation that could only be caused by an unforeseen error, malfunction, or interference, and insisting upon such a sale would put the mistaken party in an unfair position, which is contrary to the principles of fair dealing. As my learned
I have a question. I have a question here. So when the sale is going to be concluded, almost like when your client comes to know that it's 250 times more. So what was the reason to agree, and she had no clue that it is going at a price 250 times more?
Your Honor, the transaction took place via deterministic algorithms that took place while the parties were in a state of sleep. That's why there was no actual knowledge of the events taking place, and that's why there is this discussion of constructive knowledge, because it is impossible in this scenario of deterministic algorithms taking undertaking transactions, that there is a presence of actual knowledge. And that's why, to address this point of law, the issue of constructive knowledge is being taken into account.
Okay. So you mean to say that while these transactions go on continuously throughout this world, and suppose in a situation where both the parties are sleeping or unconscious or whatever, if it is not fair to one party, and then that party can always challenge that? Because I mean, I understand it's beyond the control of both these parties, the price, because both of them were sleeping. So how do you relate to that?
Your Honor, as Article 37 of the DIFC contract law states, that it would be contrary to the principles of fair dealing. So that means that if there is an acceptable or reasonable amount of unfairness in a transaction, that is the norm established in such commercial transactions, then that would not give rise to such a claim. But this was an unforeseen and unprecedented event that took place, giving rise to a situation that a transaction took place at 250 times greater than the prevailing price, which is an exceptional situation. And as my learning opposite counsel mentioned, that the respondent should not be ducking the responsibility. But I would respond to this by contending that if the respondent should not be ducking the responsibility, at the same time, contrary to the principles of fair dealing, the appellant should not be allowed to manipulate and take benefit of an unforeseen situation and gain an unfair advantage over the respondent and leave the respondent in a highly disadvantaged state, which caused a loss of over $250,000.
Okay.
Your Honor, supplementing the aforementioned point and applying Lord Mance's view in Coin Pte Limited against B2C2 Limited, which can be found in the highlighted portion on page 40 of the bundle. Would Your Honor like a brief overview of the facts?
Yeah, please.
So B2C2 initiated trades of Ethereum, a cryptocurrency, in exchange for Bitcoin on the trading platform. However, much like our scenario, due to a programmed functionality in the platform which had unforeseen consequences, the platform executed the B2C2 trades at an exchange rate approximately, just like our case, 250 times the market rate. So in this regard, Lord Mance held that the disputed trade should have been reversed as soon as the appellant, as a reasonable trader, identified that the transaction was caused by an obvious malfunction. Moreover, this means that as soon as it came to the attention of the appellant, he should not be allowed to gain an unfair advantage of the situation, and that the transaction should be voided for unilateral mistake. Moreover, looking at the highlighted portion on page 38 of the bundle, and which this is a very important point to this fact, and it's also a response to the contention of my learned opposing counsel, Lord Mance aptly stated that a computer malfunction should not be given the status of a dominating force that forces contracting parties to abide by a highly unusual and unfair trading situation arising out of the said malfunction, a situation which runs contrary to the reasonable commercial standards of fair dealing. So as contrary to what my learned opposing counsel said, that reversing this transaction would be against the principles of voluntary contractual relationships, whereas the matter of fact is the opposite, allowing such an unforeseen computer error to dominate the contractual relationship of the parties would in fact be against the principles of fair dealing. So having established that the DIFC contract law only requires establishing constructive knowledge on part of the mistaken party in a unilateral mistake claim, the next logical step would be to explore how such constructive knowledge can be inferred upon the non-mistaken party, that is the appellant. For this, Your Honor, I now refer to the Canadian High Court case of McMaster University and Wilshire Construction Limited, found on page 12 of the bundle. Would Your Honors like a brief overview of the case? Sorry, Your Honor, you're not audible.
Yes, please proceed.
In this case, the defendant had mistakenly omitted a part of a construction tender which contained a significantly important clause. The court had to consider whether the plaintiff, as a reasonable person, ought to have known of the defendant's mistake and how much constructive knowledge can be inferred on part of the non-mistaken party. So just like our case, in this case also, the transaction took place via the solicitor on behalf of the party, just like in our case, the transaction took place via the algorithm on behalf of the parties. So the question was whether the plaintiff, as a reasonable person, ought to have known of the defendant's mistake and how could constructive knowledge be inferred on part of the non-mistaken party. So in this case, it was held, applying the locus classicus of Hartog and Collins against Shields, that constructive knowledge on part of the non-mistaken party can be inferred if the mistake would also be obvious to a reasonable person in view of the surrounding circumstances. So in application of this, Your Honor, the aforementioned decision can be adopted to the modern emergence of automated contracts. It is undeniable that the disputed trade took place via deterministic algorithms without human interference, thus preventing any possibility of actual knowledge on part of the appellant. However, based on McMaster, constructive knowledge can be inferred on the basis that if the appellant was hypothetically aware of the circumstances surrounding the disputed trade, it would have been obvious to him, as a reasonable trader who regularly undertook trading on the Clarivate platform, that a mistake had occurred and the contract could not be reasonably concluded on the mistaken terms. This can be supplemented with Lord Mance's reasoning in Coin, found in the highlighted portions on page 39 of the bundle, and I quote in verbatim: a test which relates what actually occurred to natural human reactions given knowledge of what occurred. It matters not whether one assumes such knowledge at the time of the transaction or prophetically in advance. So this is a response to my learned opposing counsel's contention that the risks were known or not known before the transaction. The answer is the same. If it would at once have been perceived that some fundamental error had occurred, relief should be available. In our case, this would mean that it is irrelevant whether the programmer's mindset is irrelevant, and it is irrelevant whether the appellant had actual knowledge of the algorithmic errors when the disputed trade took place. What matters is when the matter came to the attention of the appellant's attention, he ought to have realized, as a reasonable trader, that only a fundamental mistake could have caused the highly abnormal transaction, which concluded the sale of Yapple at 250 times greater than the prevailing market price. This defeats the appellant's contention that he could not have known about the mistake, as it took place through deterministic algorithms. Your Honor, in conclusion, the respondent adheres to the view that the court of instance did not err in dismissing the appellant's claim by relying upon Lord Mance's reasoning in Coin. The IFC law statutorily accommodates the notion of a non-mistaken party's constructive knowledge within the notion of unilateral mistake. So the respondent is well within their rights, within the statutory law of the DIFC, to have this transaction voided for unilateral mistake. For the purpose of Article 37(1)(a), it is sufficient that the appellant ought to reasonably have known that the disputed trade was the result of an apparent malfunction. Furthermore, the objective reasonable person test in established case law allows for the imputation of the appellant's constructive knowledge that the disputed trade could only have occurred due to a fundamental mistake, and declaring the disputed trade void for unilateral mistake. Therefore, Your Honor, the respondent would request this honorable court to uphold the decision of the court of first instance. Thank you.
Okay, thank you. Mr. Simon, anything from your side as a rebuttal?
Yes, my lord. Thank you for that opportunity to just address a couple of points which have been raised by the counsel for the respondent. My lord, the counsel for respondent makes the argument or the point that these traders who are the appellant and whom I represent and respondent whom they represent, that these traders should have traded in a fair manner. So essentially, he's making reference to good faith. My lord, I would like to remind the court that this court applies or finds persuasive the principles of common law jurisdictions, and the respondent cannot in any way demonstrated that in their contract there was any express agreement to good faith. in the transaction. The respondent
I have
has
something. I have a question here. I mean,
yes,
does the issue of good faith equity needs to be specifically articulated in any agreement? The concept of good faith and equity, is it required to specifically articulate that or put up a clause like that in any agreement as far as common law is concerned?
yes, my lord, because in common law, good faith is applied on a piecemeal basis. So if we were to draw comparison from the civil law jurisdiction, it would normally be required, but this is not a civil law matter. And here, as the respondents counsel mentioned, these are very experienced traders. They engaged in a business transaction. This is not a consumer to business relationship. This is a business to business relationship. And so when they did that, they were trading at arm's length. And so trying to invoke the good faith principle will not sit well in this matter. Also, just to buttress that point, Article 37(2) of the DIFC contract law says, a party may not avoid the contract if it was grossly negligent in committing the mistake, or the mistake relates to a matter in which the risk of mistake was assumed, or having regard to the circumstances should be borne by the mistaken party. Both parties accept that they were aware that Clevity platform malfunctions. They accept that they deliberately entered into an automated trade. They accept.
So you are saying both the parties knew that Clevity has malfunctioned?
Yes, because it's set out in the background that Clevity does malfunction a few times. And having had that reasonable foreseeable risk, having been aware of it, and then decided to go into the trade, at this point, I'm afraid it is a little bit too late for the respondent to be arguing that the contract should be voided. Thank you, my lord.
Thank you. Mr. Fazlullah, one question to you.
Yes, Your Honor.
You confirm the point which the appellant has taken, that both the parties were aware that the Clevity platform had malfunctioned?
Your Honor, the respondent does not confer to this point at all, because the background facts are very clear on the fact that the malfunction took place while they were in a state of sleep, and there was no advanced knowledge of the fact that the malfunction took place. The only agreement that took place between them beforehand was the standard terms and conditions that they signed when trading on the Clevity platform, which was also not an agreement between the two of them, but rather an agreement with the Clevity platform.
Okay. Thank you. So that's it. I think I'll submit my point of view to DIFC. Thank you, gentlemen.
Thank you, Your Honor. It was a pleasure.
Thank you. It was a pleasure too. Thanks.
Thank you, Your Honor.
Thank you, everybody. Thank you.
Thank you.
Thank you.